The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning and welcome to this special remote session of the North Carolina Court of Appeals. I'm Richard Dietz. I'm joined by my colleagues, Judge Hunter Murphy and Judge Fred Gore. And we have one case on the argument calendar today. For the benefit of the public, there are two cases listed on the public calendar. The second case, the parties have withdrawn the appeal. So we'll be hearing one oral argument this morning, and that's in case number 2611, State versus Alvarez. And we've confirmed that the parties are ready, so we'll hear from the state.
Thank you, Your Honors, and may it please the court. My name is Zachary Dunn here on behalf of the state in this matter. When officers stopped Mr. Alvarez's vehicle on a stretch of road in Rowan County in June 2018, they did so lawfully. First, the officers witnessed Mr. Alvarez commit a traffic violation, which provided them with reasonable suspicion to effectuate a seizure. Alternatively,
Mr. Dunn, let me stop you right there as far as how you're starting off your analysis. When you are looking at that argument and how you're starting off with reasonable articulable suspicion, isn't it not true that he availed himself to the checkpoint before there was a stop?
Well, Your Honor, yes, that's correct. So Mr. Alvarez...
Let's stop at that part of the analysis. So if he availed himself to the checkpoint, do we not start with the analysis of the constitutionality of the checkpoint before we then evaluate whether there is reasonable articulable suspicion for further investigation?
Well, a couple of points on that, Your Honor. I would respectfully point the court to two cases from our Supreme Court, Griffin and Mitchell. And I want to quote from Mitchell just real briefly because I think it's really important. Quote, police officers may certainly develop reasonable articulable suspicion to stop a car based upon their observations unrelated to the checkpoint that a crime has been committed. And armed with that suspicion, the officer's seizure of the vehicle is proper regardless of the constitutionality of the checkpoint. So it's our position that really the analysis should start with reasonable suspicion because, from Mitchell's holding, it essentially says that police officers don't have to blind themselves to facts and circumstances, things that they see prior to a seizure, prior to a car stopping at a checkpoint. And armed with that suspicion, they can, and the court used in that case, effectuate a seizure, although the stop was not per se based on the reasonable suspicion, the seizure occurred after the officers gained that reasonable suspicion. So basically,
does that fly into the face of the fact that we have to address the constitutionality of the checkpoint, which would lead to them to be there to effectuate that stop to begin with?
I don't think so, Your Honor, respectfully, just from that quote at Mitchell, but also Griffin, which is another one of the reasonable suspicion arguments in the context of checkpoints. And it has a very similar holding, held that where officers possess a reasonable articulable suspicion, a traffic stop is constitutional and, quote, it is unnecessary for this court to address the constitutionality of the driver's license checkpoint.
What do we do with the fact that the trial court made a finding that one of the reasons for this traffic violation, the shifting out of the lane, was that the checkpoint was there? So what do we do if we conclude that the checkpoint was unconstitutional?
So, Your Honor, that's finding of fact number 11. That's correct that the trial court found that. Of course, we have challenged finding of fact number 11 as unsupported by any competent evidence in the record. Just like to touch on that for a moment. Really no evidence or testimony supports that finding of fact. Deputy Hsu, which was the officer in charge at the time at the checkpoint itself, testified that when motorists came around the bend, there was a slight bend some distance away from the checkpoint, that there was still a brief moment where before they actually realize what's going on and they're able to slow down. So there's some evidence that there's some recognition by drivers before coming to the checkpoint, but also.
Mr. Dunn, given the low flow of traffic in this area, isn't that a pretty limited data set to be making that conclusion from when you do have at least one car that the trial court found was run off the road due to the location of the checkpoint. It's not like we're dealing with a checkpoint where they check in this area, every 6 months and no one else has ever driven off the road. Everybody else has plenty of time to stop. We have a very limited data set here of sight distance. So I guess it comes down to what Judge Dietz is getting at with what I've kind of renumbered as finding of fact 13, 11 or 13, however you want to look at it. But we have some circumstantial evidence, at least, that this is impacting the driver's ability to make this turn safely. And you don't have a large amount of cars or any testimony to a large amount of cars that were able to negotiate this safely. So why shouldn't we rely on the circumstantial evidence that the trial court found and found to be more credible that this did have an impact?
Well, Your Honor, what I'd say to that is we have this finding of fact from the trial court. And of course, we have to look to see, because it's challenged, we have to look to see whether or not there's any competent evidence in the record to support it. And here, our position is that there simply isn't. The only testimony that was presented at the suppression hearing was from the 3 officers who were at the scene at the time. None of them testified that there was a problem, like Your Honor mentions. And I would actually also point this forward.
Given the testimony of this gentleman going off, at least some evidence of that existing problem that is not beyond reason, not beyond what a trial court can do with circumstantial evidence. Obviously, there's evidence pointing in the way the state would like to interpret this, but any competent evidence, we do have at least one vehicle that went off the road in the location. Tell me why that's not enough, or what would have been necessary to be enough to be competent evidence in the state's view that
I think
this was not that this checkpoint itself did not contribute to the car going off the road.
I think we'd have to have some evidence or testimony that it impacted drivers. So, we don't have any testimony, for instance, from Mr. Alvarez or from anybody else saying that this checkpoint interfered with drivers. Of course, there was no testimony that other drivers ran off the road before coming to the checkpoint. All we have is one driver. The only evidence in the record is we have one driver who ran off the side of the road before correcting and coming to a stop at the checkpoint. And we have officers testifying that indicated to them that there might have been some impaired driving going on. Deputy Shu testified that indicated to him that not that the checkpoint had anything to do with the failure to maintain lane control, but rather that there might be some impaired driving going on.
But that's just a lay opinion by the officer that it seems the trial court didn't give any credibility to or give any weight to. It gave more weight to the actions described as opposed to their opinions, right?
Excuse me, I think that's correct, but really I would just circle back to the standard for when reviewing a finding of fact, which is just any competent evidence in the record. And here, the only testimony presented by the 3 officers, there's simply no testimony that this checkpoint in any way contributed to Mr. Alvarez's failure to maintain lane control.
Mr. Dunn, was he cited for failing to maintain lane control?
I don't think he was, Your Honor. A couple of points on that. Really, the failure to maintain lane control is important when judging whether there was reasonable suspicion to stop Mr. Alvarez. So in addition to the just the bare failure to maintain lane control, which would have been a violation of the state's motor vehicle laws, like I mentioned earlier, Deputy Shu testified that it indicated to him that there might have been some impaired driving going on. And so
I guess I'm still going back to my initial question, Mr. Dunn. And I understand your best argument right now, and the best horse you got running is this reasonable articulable suspicion argument. Because the issue that we cannot turn a blind eye to is that officers did not rush to the vehicle when they saw him run off to the side of the road for this Chapter 20 violation that they allege. If they had done that, I think you might have more water in your bucket for that argument. But at this point, I don't think you can get around the issue that law enforcement stayed where they were and allowed the defendant to come to the checkpoint. Is that not, am I missing that chronological? They saw the infraction that they alleged, they stayed put, and then allowed the defendant to arrive at the checkpoint. Is that correct?
That's correct. I think you have the timeline correct. I would note a couple of things that are in the record. Officer Tester testified that he was the first one to approach the car. And the testimony was that when they reached the car, officers, I don't know if they used the word immediately, but ordered Mr. Alvarez out of his vehicle, which is something that you don't normally see at a checkpoint stop. And Deputy Hill testified that if Officer Tester had not ordered Mr. Alvarez out of the vehicle, that he would have. So yes, there is the chronology of the events is that Mr. Alvarez ran off the road and then corrected and stopped at the checkpoint. But I think based on the testimony of the officers, what we have here is something that they recognized as suspicious, reasonable suspicion, and then they acted upon that to order Mr. Alvarez out of the vehicle. So,
but getting back to the point we were making earlier, so there's multiple law enforcement officers. There's at least one patrol vehicle with its lights activated. If you're an approaching driver and you see that, you're not going to immediately know it's a checkpoint. You might think, for example, that there's been a serious accident ahead. And so you may slow down and briefly begin to pull over, pull out of your lane until you can determine what's going on. Why isn't that a reasonable inference that can be drawn from these facts that was the reason for the departure from lane? And if that's a reasonable inference, isn't that the competent evidence that's needed for us to sustain the findings by the trial court?
Well, what I'd say to that, Your Honor, is there's just no testimony that the checkpoint itself contributed to the failure to maintain lane control. There was no evidence put on that any other vehicles, for instance, had a problem with running off the road before coming to a stop at the checkpoint. And we have the testimony from Deputy Chu, which says that when motorists come around the bend and approach the checkpoint, there was still that brief moment where they realize what's going on and they're able to slow down. So we would just say that there's no competent evidence to support that finding of fact. Originally misnumbered 11, I think. You, Judge Murphy, it's renumbered as 13, but that would be the state's contention on that point, Your Honor. So unless there's any other questions on reasonable suspicion, I'd like to turn...
Before you move on, so I was muted there for a second. My apologies for that. Before you move on from that, I want to just talk a little bit about, the burden the state carries here. We have a warrantless search or warrantless seizure, and the state never loses their burden to show that an exception applies. So what is your burden of persuasion then that that the checkpoint did not cause the vehicle to swerve? Is there a burden on the state there to produce evidence that it didn't contribute to the car going off? Or are you suggesting that there's some type, or given the testimony by the officer, there was some type of burden shift going on that the defendant needed to put on evidence to show that that is what caused him to go off the side of the road there?
Your Honor, I'm not sure. That's a great question. I'm not sure that there's a burden shifting framework. What I would say is when the defendant files a motion to suppress, the burden is on the state to show basically that the checkpoint, or excuse me, that the seizure was lawful. And so here the state put on evidence and testimony from 3 officers, none of which testified that the checkpoint had anything to do with the failure to maintain lane control. And so, of course, defendant was free to put on such evidence, but when looking at a finding of fact, the court just looks to see if there's any competent evidence. And based on these officers' testimony, it would be our submission that there just isn't any competent evidence to support the suggestion. I think it's just a mere suggestion that the checkpoint may have caused the failure to maintain lane control.
And the last point, Mr. Dunn, is it not, I guess in Mitchell Griffin, is it not distinguishable that some of the conduct in those defendants there was conduct that was trying to avoid the checkpoint in some of those cases versus, and in contrast to this case where the defendant did drive all the way up to the checkpoint?
That's certainly a factual difference between those two cases and this case. But I think that the holding is still good. I mean, I think that the officers seeing reasonable suspicion, seeing something that gives them that objective justification to believe that criminal activity might be afoot, gives them the permission, everything that they need to go ahead and effectuate that seizure. So although there are some factual differences between those cases and this case, I think really the Supreme Court's holding that officers certainly don't have to blind themselves to facts and circumstances that are going on while they're operating a checkpoint, and that armed with those facts and circumstances, that reasonable suspicion, they're permitted to effectuate a seizure would hold here, and so the stop was lawful on that basis. Unless there's any other questions on that point, I'd like to turn, if I might, to the checkpoint itself.
Mr. Dunn, as you get into that, and just kind of to focus in the argument a little bit, I've got a big question on under the checkpoint plan from the Rowan County Sheriff's Office at record 14 through 15. Under the procedures for setting up the plan under B and C, was Sergeant Myers the supervisor authorizing the checkpoint, or was that Deputy Shue? I think there's a little bit of discussion. Obviously, Deputy Shue was the supervisor, the one making decisions on the scene, but it appears from at least even Deputy Shue's testimony that Myers was the authorizing supervisor under the Rowan County Sheriff's Department or Sheriff's Office checkpoint plan.
I think that's right, Your Honor.
Position?
I think that's right, Your Honor, and I apologize, I don't have that directly in front of me, but I'll certainly take a look when I sit down. But there is testimony that's correct that while Deputy Shue was the officer in charge at the scene, the lieutenant or sergeant Myers was the officer that authorized the checkpoint. I believe it's on transcript page 12 where Deputy Shue testifies that he got into contact with Sergeant Myers, gave him the reasons for why they wanted to set up the checkpoint, and then received the authorization, and then of course filled out that form, that checkpoint form, Your Honor.
So you'd agree then that the testimony Deputy Shue gave at page 7, lines 17 and 18, was there a supervising officer for the checkpoint? Yes, there was. It was me. In context there, that's referring really to on the scene supervisor and making the decisions on the scene, correct?
I believe that's the best reading of the transcript. Yes, Your Honor. Now, I'd like to, I'm sorry. Okay.
Thank you, sir.
Yes, thank you. If this court agrees with the state on the first issue, of course, it need not reach the constitutionality of the checkpoint, but of course, conversely, if the court doesn't, then some analysis of the checkpoint becomes relevant. And the standard really in our courts at least comes from VZ. When determining the constitutionality of checkpoint, the court has to undertake a two-part analysis. The first of which is to inquire about the primary programmatic purpose. And then second, if a legitimate primary programmatic purpose is found, then to look to the reasonableness of the checkpoint under the circumstances. And so, of course, for that first inquiry on reasonableness, in McDonald, this case, and this court in 2015 explained that the court has to examine the available evidence to determine the purpose of the checkpoint program. And really cases from this court, but also the US Supreme Court, I'm thinking of City of Indianapolis versus Enman, and again, Veazey, really set up this dichotomy where on the one hand, checkpoints which relate to roadway safety are a proper purpose, but on the other hand, checkpoints that are set up for general crime control purposes are not. And the state believes that this checkpoint really falls into that former category. All of the testimony and all of the evidence that was presented was that this checkpoint was set up for two purposes, which is to check for driver's licenses and to check for motor vehicle violations, Chapter 20 violations.
Mr. Dunn, what was the purpose in the form, the form of the document, as far as the four corners of the document and the initial motivation from Deputy Shue? What is your argument or your stance? Because I'm not reading the form on the document to be just Chapter 20 per se, but was it not the fatality, vehicle fatality accident that led to this being the true motivation?
That's correct, Your Honor. So the form, I agree that the form says that they decided to set up this checkpoint because there was a single accident fatality right around that area. I think it was either a day or 2 days before they decided to set up the checkpoint. But there's testimony from Deputy Shue that the purpose of the checkpoint, which is really what the primary programmatic purpose, what they're looking for when they stop vehicles, not the reason why they chose this stretch of road, which comes in the reasonableness determination, but what they were really looking for when they stopped every car that came through. There's uniform testimony that was for Chapter 20 violations and to check for driver's licenses.
Isn't there a necessity for law enforcement to be able to establish a history of those violations in that general area as well? And I'm not hearing in the transcript or reading the transcript, I'm not seeing where they were able to establish a history or a pattern of Chapter 20 violations in the area that would lead to a basis for that area being chosen. Am I correct on that?
Well, Your Honor, respectfully, I don't think that comes into the primary programmatic purpose inquiry. Really, that inquiry is focused on what the officers were looking for when they stopped vehicles. Really, the reason why the officers chose a particular stretch of road, and it comes in not in the primary purpose inquiry, but later when judging reasonableness, and only then as one of many factors considered in the Brown versus Texas three-part inquiry. So I don't think, and I wasn't able to find a case on the point holding that the officers, there must be some sort of means and fit test almost between why the officers chose that stretch of road and what they were looking for. So just on that first point, on the primary programmatic purpose point, Your Honor, we believe that the trial court erred by looking at that information in that primary inquiry, where all of the evidence and testimony was that this checkpoint was looking for violations of the motor vehicle laws and driver's license checkpoints, which this court felt.
Mr. Dunn, would it have been a proper purpose under the checkpoint plan for the county to be checking for other Chapter 20 violations? I'm looking at their checkpoint plan 1A references specifically 20-163, 116.3A. And the purposes in 16.3A for a checking station are only license, registration, insurance information. Other Chapter 20 violations aren't laid out by the legislature there. So would other Chapter 20 be proper under the plan that's referencing the statute?
Well, a couple of points on that, Your Honor. I don't think that the checkpoint plan from Rowan County can determine the constitutionality of the checkpoint. And I would point Your Honor, to a couple of cases from this court where the court said that looking for Chapter 20 violations was a valid primary programmatic purpose. VZ, for instance, noted that the primary purpose in that case was the enforcement of the state's motor vehicle laws, and all the way up to a case, it's an unpublished case, but a case from 2020, Sprinkle Surratt, the court used the specific formulation that the primary purpose was to, quote, search for NC General Statute Chapter 20 violations. So I think just based on that case law, that looking for Chapter 20 violations is a permissible primary purpose.
So
Well, let me ask you this. Could it have been the purpose of the supervising officer, Sergeant Meyer, if that was an authorized purpose under the plan dictated by the sheriff? So if he didn't have authority to give a certain purpose and give a reason of Chapter 20, could that ever be a proper purpose if that supervising officer setting up the checkpoint didn't have authority to set up a checkpoint for that expanded purpose beyond just the checking stations?
Yes, Your Honor, I believe that it is. I mean, again, I don't think that the Rowan County Sheriff's Department and their internal regulations can really bear on the constitutionality of the checkpoint, especially when we have cases from this court saying that searching for Chapter 20 motor vehicle violations is a proper programmatic purpose. I see that
So I'm sure I understand. Do you agree that there are two purposes that are authorized in the program, and we're not talking about impaired drivers, so we must be talking about the driver's license check part of it? Do you agree?
I'm sorry, could you say that again, Your Honor?
So do you agree that there's two purposes? The program has lists two, driver's license and impaired driving. And do you agree that we're only talking here about the driver's license one?
Yes, Your Honor.
And then, so the state's position is that you could have a checkpoint like that and the officers walk up and say, we don't actually care about your driver's license, but we are concerned about other potential regulatory violations. So let me ask you some questions about those. You think that would be permissible?
I don't think so, Your Honor. I think if there was testimony that the officers weren't really looking for driver's licenses, that would potentially create problems for the state. But I think, looking for Chapter 20 violations, if you see cars coming through the checkpoint and you notice something that is a violation of the motor vehicle laws, again, I think that the officers were just indicating that they wouldn't turn a blind eye to that and would enforce the state's motor vehicle laws. So, Your Honor,
those other things, though, those can't be the purpose. Doesn't the purpose have to be checking driver's licenses? And that's not what, even on the form, that's not what was indicated was the purpose of the stop of the defendant, right?
On the checkpoint form that's in the record, you're right. It doesn't say that, but we do have testimony from the officers that was their purpose, that they wanted to check for driver's licenses and then the motor vehicle infractions. See that I'm
Mr. Dunn, I will defer to Judge Dietz on extending your time, but my last question on this issue of the checkpoint is that prior to getting to those other things, as Judge Dietz just asked, isn't it a requirement to establish that the checkpoint itself was constitutional before you could then get to those unenumerated Chapter 20 violations that are not listed in the statute? Isn't it a requirement to establish the constitutionality of the checkpoint before you can establish the authority for enforcement for those other Chapter 20 violations?
I think that's right, Your Honor. And, in looking at the constitutionality of the checkpoint, of course, we're still on that first prong, the primary programmatic purpose. And so I think, with the officer's testimony that they were looking for driver's licenses and then the motor vehicle infractions, that just based on the case law from this court, McDonald, VZ, and others, that is a proper primary programmatic purpose, which is hard to
But
say.
in McDonald, wasn't it discussed by the court that when there is two purposes established, that the trial court needs to identify which one they're hanging their hat on as well?
I think that's right, Your Honor.
And we do have two. Are you conceding that there could be argued two purposes, one for the vehicular issue or vehicular accident that happened on the form, and then the testimony of what law enforcement said they were trying to do? So are you conceding that there are two purposes out in the trial court's purview?
I don't think I would concede that, Your Honor, respectfully. I think that the proper primary programmatic purpose that the officers said that it was the reason for the checkpoint. What they were looking for was the two things: driver's licenses and then violation of the state's motor vehicle laws. I think that the question of why the officers chose this particular stretch of road just doesn't come into play at all during that primary programmatic purpose inquiry, but is really something, and I see that my time has run out, if I might just finish my thought here, is something that only comes into play in the reasonableness inquiry. So I see that I'm out of time, so unless there are any further questions, the state would just respectfully request that the trial court's order granting the defendant's motion to suppress be reversed, either on the reasonable suspicion grounds or due to the constitutionality of the checkpoint. Thank you.
All right, thank you, counsel. We'll hear from the appellee, but first let me just confirm I got a note that we may have some connectivity issues.
Yeah, if you'll give me just 1 minute, I'm going to change my networks real quick. So it just kind of keeps coming and going a little bit on the audio. So give me 1 second. All right. Judge Dees, can you see and hear me okay now?
Turn your video back on. We can hear you fine.
Your webcam. Is it still showing my video is muted, or did my video come back on?
Okay, we got you now.
Okay, thank you. All right, sorry about that, everyone.
All right, we'll hear from the FLE.
Good morning. May it please the court. I'm Catherine Vandenberg of the Office of the Appellate Defender representing Mr. Alvarez. There are 3 main points I'd like to discuss. First of all, the trial court found that there was no supervisory purpose shown for this checkpoint. And second of all, the trial court found that there was no legitimate purpose for this checkpoint. And each of those findings ends the inquiry into the checkpoint because the trial court made findings and conclusions. They were supported under the strict standard of review. They were supported by competent evidence, and they supported the conclusion of law that this checkpoint violated the Fourth Amendment. And then I also wanted to speak to the state's reasonable suspicion argument. So starting with the supervisory level purpose, the Edmund case says that the purpose inquiry has to be conducted only at the programmatic level, supervisor level. And as the state conceded, that was Sergeant Myers in this case. I'd also point you to The Rose case from this court, at page 292, the court cites to a Georgia case, and they use language that I think is useful, and they talk about there being a constitutional prerequisite that there be a supervisory purpose. And the trial court made a finding in this case, a finding of fact, on the record, page 28, paragraph 7, that there was no supervisor testified about a purpose. And then the trial court also concluded on record page 30, conclusion number 3, that no supervisory purpose was shown. Under Rose and under Edmund, that ends the inquiry of the constitutionality of this checkpoint by itself.
Well, Ms. Vandenberg, why aren't we that the trial court didn't make a determination of the purpose at all? That it was either this or it was this other improper purpose.
Right.
You know, the suggestion here is there's no evidence. Well, there's some evidence that the trial court could have relied on. The trial court could have chosen to rely on the testimony. So that's an issue with finding of fact 10, that there's no evidence about this. But semantics aside, whether we're talking about no evidence or lack of credible evidence, is there there's not a burden on the state to bring in the supervisor to testify about what his or her purpose was, correct?
I think there is a burden on the state to show the supervisor's purpose. Now, I suppose they can show that there are cases that say if there's no conflict in the evidence and everyone can just sort of know that that's what happened, that would be one situation, but that is not our situation, right? The checkpoint form says something different, and Deputy Hsu testified to 2 or I think 3 different purposes. So where there is a conflict, I think the state does have the burden to prove that there was a supervisory purpose. It wouldn't have to come from the person's testimony, but they have to prove it.
Well, then is the finding of fact, which is labeled as number 10, it's the 12th finding of fact, record page 29, then is that then not supported by the record that there was no evidence offered to the purpose?
Well,
or the situation where we may need to remand to say, hey, there's evidence here. It appears you're resolving this as a lack of credibility, but if that's the issue, you need to say that.
well, I think beyond the supervisory purpose, I think the state still has the burden to show it. And I think the trial court's conclusion on record page 30 that says there was no supervisory purpose shown is enough on that prong, just the supervisory prerequisite. But I would also then go to my second point, which is that the trial court found there was no legitimate purpose for this checkpoint.
I guess, Ms. Vandenberg, I'm sorry to interrupt you, but on that point, before you move on with what Judge Murphy brought up, wouldn't there need to be proper findings to establish that, to bring us to satisfy the competent evidence standard, to make sure that that is flushed out in this order, to make sure that we can clearly identify how the trial judge ruled?
Well, certainly the findings could have been more thorough, but I think there's enough here that you can make inferences from what the trial court said. I mean, there was no testimony from Sergeant Myers at all, and clearly the testimony about the supervisory purpose was not consistent. So the trial court made the finding that there was no supervisory purpose shown, and then the conclusion that, or I'm sorry, the trial court made the finding that the supervisor did not testify, and then concluded that there was no supervisory purpose shown. To me, that is sufficient, although not very thorough. That is sufficient to end that inquiry. But I think separately, if you go on to whether there was a legitimate purpose at all, the trial court made a very clear finding on that point. On record page 30, conclusion number 2 says the primary purpose was not for one of the valid enumerated purposes in Rose. And in Rose, the valid enumerated purposes are the ones, approved by the Supreme Court: license checks, immigration, DWI, and then the sort of narrow investigation of a crime. Maybe that just happened and they can stop people to see if they have information. And as you all spoke about earlier, the only one that applies in this case is the license purpose. And so the trial court found specifically the purpose of this was not for one of those purposes. So that's kind of a backwards way of saying it, but she's saying this was not done for a license check. And that finding is very well supported by the facts. It may not be that every ounce of evidence supported that, but the trial court listened to the testimony, and this court has to give deference to her findings. And her findings were this was not for a license check. It was for speeding and for a response to this sad accident that the people were upset about. And, you know, the officer, she wanted to do something. And so he filled out this checkpoint form. And there's no logical connection between the speeding accident and checking for driver's licenses a few nights later. And that's what the trial court was troubled by. And that's what the trial court found.
Ms. Vandenberg, we're kind of using the words kind of found and conclude almost synonymously here. And part of that is probably maybe part of 2 regarding there is no primary purpose and not a purpose that's proper under Rose here in conclusion of law number 2. Maybe part of that is a finding of fact and is better categorized as a finding of fact. But can you point me to any cases where even if we assume that, we can use that to read into this finding of fact 10 on page 29 about where the trial court specifically says no evidence, not a lack of evidence, not persuasive evidence, not that the state didn't meet their burden to prove the primary purpose? Is there any case law where we can use what may be a part of the finding of fact and the conclusion of law to support what may be an incorrect finding of fact in the finding of fact section?
So you're saying that you're contending the incorrect finding is saying that there was no
evidence.
Given
that there was no evidence offered. There was evidence offered regarding the purpose, but that if we use the interpretation and conclusion of law 2, that seems to be pointing to a lack of a proper purpose. If we consider that as part of the findings of fact, we can kind of read that in 10. But is there any case law you can point us to where we've done that before? I'm not saying it's a bad argument and that it's not something that makes sense, but I'm not sure that that's a proper function of this court to read a part of a conclusion of law that may be a finding of fact into the finding of fact.
I'm not coming up with a case off the top of my head. There's certainly case law that says if it can be labeled as one or the other and you read it as what it is. And I think that it's true that there was no supervisory testimony in this case about what the purpose was. That's a valid finding of fact. I also think that you can disagree with a fact finding and still reach the legal conclusion. You have all the same facts in front of you that the trial court does, and I'm sure there are cases where one finding of fact is found to be incorrect, but the conclusion of law is still upheld.
But usually in those cases, it's not where the trial court is expressing that no evidence was offered on this issue, and we would find, yeah, there was evidence offered. Doesn't that erode the faith we can have in the conclusions? If the trial court either misremembered, I know this order came 4 months later, and possibly even before a transcript, misremembering the evidence, since the trial court didn't find it to be credible, it kind of forgot about it, as is drafting through the order. I think it's asking a lot of us to set aside words of the trial court, say no evidence was offered when there was some evidence offered. It may not have been persuasive or credible evidence, but there was some evidence offered. So I think that's my concern in terms of, if we went with all your arguments, whether it be appropriate to affirm or appropriate to remand, to clarify this a little bit, as Judge Gore's getting into at the end of the state's argument.
Right.
So I guess I just don't see anything in our past cases that would suggest it'd be appropriate to ignore this finding of no evidence being offered and not at least remand it because of this mistake. If that's where we ended up.
I don't have a case on that off the top of my head, but I feel certain that there are cases where the appellate court finds that a finding of fact is incorrect and yet still agrees with the conclusion of law. I mean, there's certainly cases that say no matter what the trial court's reason was, if the appellate court, do a de novo review, we find that this is the correct conclusion. Going back to the legitimate purpose, there's the record page 30 conclusion 2, then there's also record page 31, paragraph 5. The trial court finds the checkpoint at this intersection did not address a grave concern of the public and therefore violates the Fourth Amendment. And further at the hearing in the verbatim transcript at pages 48 and 49, the trial court said, the checkpoint was created because of a one-car speeding accident, and that is not reasonable. So there are multiple places where the trial court explicitly finds the purpose of this checkpoint was not a license check, and that is the only approved purpose for a checkpoint that will get you around a suspicionless stop. The brief talks about the reasonableness factors in detail, and in my mind, there's no reason for this court to go there because there was no legitimate purpose to start with, and the trial court made that finding. And if there's no legitimate purpose, there's nothing to balance the other factors against. I'm glad to talk about the other factors if you all would like, but otherwise I'll move on to the reasonable suspicion argument. I have a few points about the reasonable suspicion argument. First of all, of course, I'm in agreement with you that the checkpoint caused or contributed to or was related to this car going off the side of the road. I noticed that the state continued to say the car ran off the road, and I think that is an inference that you don't have to make. I think that the driver could have chosen to go off the road, as you were saying, Judge Dietz. There's evidence that the checkpoint was around a corner. It's late at night on this rural road. You know, you come around the corner and see what's happening. You know, is there a wreck? Is there a police car coming and I need to move over? I think it's perfectly reasonable to pull over for a moment and see what's happening and then go, oh, okay, this is a checkpoint. I'm going to go ahead and go to it.
Ms. Benner, isn't it also in the same brushstroke arguable sitting as officers on the road at night that that could have been as a result of something else going on with the driver, even in light of not saying that the checkpoint could have led with the lights flashing, the curve, but isn't it also arguable that there could have been some credence to their suspicion as to the time of night and there being something going on with the defendant?
Well, that's a possibility. I mean, we don't know what's going on in the driver's mind. And of course, the test is not the subjective view of the driver. It's whether the reasonable suspicion existed in the minds of an objective officer, a reasonable officer. And I think it is not reasonable to conclude that watching someone briefly go off the road and then come right back on and approach the checkpoint, I don't think that gives you reasonable suspicion under the totality of the circumstances. I also would take issue with the idea that that going off the road was illegal and violated the statute, because that statute requires two components. One is that the person leaves the lane, but the second component is that they leave the lane without ascertaining that it's safe. And there's no evidence in this case that Mr. Alvarez briefly going over onto the shoulder was unsafe. In
But
fact,
isn't it also true, Ms. Vandenberg, we don't have to have a criminal, statute violation to allow the officer to perform reasonable.
that is true. Yes, the bigger test is whether there's reasonable suspicion, but the officers did say, we thought he violated that law, and I would contend that they did not have reasonable suspicion to think there was anything wrong. It's not illegal to pull over on the shoulder of a road. People do it for all sorts of reasons. And there's a very reasonable inference to be drawn that that's what happened in this case. I think you can infer that the driver pulled off the road and then came on up to the checkpoint, and that didn't violate a motor vehicle statute.
Ms. Vandenberg,
Mhm.
Vandenberg,
Yes.
with the cause, the checkpoint, or the role the checkpoint played in the failure to maintain lane control. It seems to be coming, the argument really seems to be coming from this unrelated to the checkpoint language between the commas in Mitchell.
Mhm.
Is there any other cases that you want us to consider about what is and what isn't related to the checkpoint?
None that the state hasn't already talked about. I mean, there were the two cases where one, a person made a valid left turn and the court held that's not that doesn't give you reasonable suspicion on its own, but it can make you suspicious enough to follow that person. And that's what happened in that case. And I'm mixing up which one that is. But, it's not that if someone tries to avoid a checkpoint. I think it's fair to think, why is that person trying to avoid the checkpoint? Maybe there's something going on, and to follow them and try and develop full reasonable suspicion. So that's one type of case. But that didn't happen here, of course, because Mr. Alvarez didn't turn around and leave. He kept going and approached the checkpoint. And then the other type is when someone is, completely turns around. I think one of the cases they committed a motor vehicle violation. And I would just distinguish those completely, because it's a different case when someone doesn't come to the checkpoint and when they do come to the checkpoint.
And Ms. Vandenberg, on pages 23 to about 25 of your brief, you kind of mentioned an alternative basis for showing a lawful seizure of the drugs within the vehicle. State in the reply brief brings up this wasn't part of the argument below, wasn't part of anything put on, wasn't part of the motion. Do you have a response to how this argument at page 23, this alternative basis to uphold the order, was preserved or not preserved?
Yes. So first of all, as you all spoke about earlier, it's the state's burden, and it remains the state's burden to prove that the evidence seized was seized constitutionally. And also, if you look at the procedural history of how this, argument came about, Mr. Alvarez filed his motion to suppress. The state filed no response and raised no, written argument. And the court granted a hearing. They came to the hearing. The state elicited all the testimony about the checkpoint. Although they did mention a couple times, well, did you think you had, suspicion for impaired driving? And then after the evidence was in, the state, before it got into its checkpoint argument, talked for about a page about, and also we had reasonable suspicion for this. So it was discussed, but not until after all the evidence came out. And then defense counsel responded to that in his argument. And then the trial court, after hearing those evidence, all that argument, made its ruling. And so I think under those circumstances in particular, it can't be the defendant's burden to try and show that the evidence seized wasn't not constitutional. That just seems completely backwards to me. I think it's always the state's burden, and especially where they raise this as sort of an afterthought, that it's not fair to impose that burden on Mr. Alvarez.
I don't necessarily disagree with you in terms of imposing burdens, but I'm looking at record page 11, which was the defendant's motion to suppress at the trial level.
Mm-hmm.
And to me, it is only talking about the lawfulness of the stop, and even concludes by that opening sentence that such evidence was seized or result of substantial violations to NCGS 20-16.3A. So why wasn't the hearing, or why shouldn't we rule that the hearing was limited to only the purposes set out in the opening to the motion to suppress? Is there some language in there that you think expands it to cover this later search of the vehicle?
Well, I mean, the very first opening sentence, such evidence was obtained as a result of substantial violations against illegal searches and seizures protected by the United States Constitution. That's very general language that ought to cover whatever comes up. It's also true that when the state brings up an alternate argument like they have, that the court still can, or the trial court heard that argument and made a ruling on it, at least implicitly. You know, Judge, her name, the Superior Court judge was a resident Superior Court judge. She's heard hundreds of motions to suppress, and she heard the state's argument. She didn't misunderstand it. She heard what they were talking about, and she gave it no credence at all. You know, and a couple of her findings at least touched on the argument about reasonable suspicion, talking about that the checkpoint contributed to the car going off the road. And I think that's enough for this court to find that there's an implicit ruling on the reasonable suspicion argument. If there are no other questions, I will thank the court and ask you to affirm the trial court's ruling below.
If you'll give me just 1 second.
Sure.
I just double check my notes, make sure I didn't have anything else for you, Ms. Vandenberg.
Okay.
Do you agree with the state's characterization of who the supervisor was under the Rowan County Sheriff's Office checkpoint plan, that it was Sergeant Meyer and not Deputy Shue?
Yes, I do. And I
Ms. Vandenberg, I've lost you if you can still hear me.
I can hear you. Can you hear me?
Okay, I missed your response. You said, and actually, and then it cut out.
Oh, okay. There's another point I wanted to make that I forgot about. And that is whether checkpoints can properly have the purpose of looking for motor vehicle violations outside of license and registration. And that's not really necessary for this court to find in this case, but you know, if you're going to touch on that, I would disagree with the state that that is a proper purpose. Certainly Delaware versus Prowse said it is not a proper purpose, and Judge McGee in the VZ opinion, and I can't find her quote right in front of me, but she talked about that the U.S. Supreme Court cast doubt on whether that could be proper, and the VZ opinion said we're not sure that's really a proper purpose, and the logic behind that is moving violations, and that's discussed in Delaware. Moving violations are best, you know, enforced by patrol officers or people parked on the side of the road, not by checkpoints, because checkpoints by their nature give some notice to the drivers. And so that doesn't justify invading the privacy of all the general public. The way to enforce moving violations is to stop people who commit moving violations. And so I think the limited ability to get around suspicionless searches should remain limited, and it shouldn't be spread out to all of Chapter 20. It's true that the Sprinkle Surratt unpublished case that came out just earlier this year, it seemed to say that that was true, and I would caution the court not to continue that line of thinking, because I think it's incorrect.
Ms. Vandenberg, one last question I have is,
Sure.
what is the defendant's position as far as once the court makes a determination on constitutionality of the checkpoint? Obviously, if we find it constitutional, then we do move forward to the evaluation of reasonable articulable suspicion. But what is the defendant's position if this court rules that the checkpoint was not constitutional? Do we move forward? Do we stop there? Are we done? Do not pass go, or do we go to the reasonable articulable suspicion argument?
Mr. Alvarez would be very happy if that was the end of the case, and I think that would be fine to just affirm what the trial court did, because I think the reasonable suspicion argument, the trial court implicitly ruled on it, and you can affirm that ruling. I think, you know, I also believe that there was no reasonable suspicion, and you could certainly engage in that analysis and affirm what the trial court did based on the discussions earlier. Okay, thank you very much.
All right, thank you, counsel.
Mhm.
We'll hear a rebuttal from the state. Let's do 2 minutes, counsel. Thank you.
Thank you, Your Honor. I appreciate that. A couple of minutes of extra time, and may it please the court. Just a couple of points that I wanted to touch on in rebuttal. The first is the question about kind of an alternative basis on the reasonable suspicion argument. You know, that the argument that the trial court didn't make any findings of fact or conclusions of law about what happened after the vehicle was stopped, whether there was a chain of custody between when the vehicle was stopped and when the drugs and other paraphernalia was found. And our position on that is simply that that was not an issue at the trial court level. As I believe it was Judge Murphy pointed out and pointed to the motion to suppress itself, there was no question in the motion to suppress. There's no argument about whether or not anything happened after the vehicle was stopped to when the drugs were found. And so I think at least for this court's decision, that's not really an issue. If the court were to find that the officers possessed reasonable suspicion to effectuate a seizure, that would be the end of the inquiry as far as this court is concerned on that point.
Mr. Dunn,
yes.
but doesn't invoking these portions of the Constitution stand for the fact that the state's going to have to show us why this evidence should be let in, even if it's not specifically laying out these facts in the affidavit? You know, especially I'm looking at between the semicolons, the opening paragraph that says such evidence was obtained as a result of substantial violations against illegal searches and seizures protected by the United States Constitution and the North Carolina Constitution. If there's not an ability to search the car at the checkpoint and there's no consent to search, why isn't that covered in that? I know that the facts laid out and the bulk of the argument all surrounded the checkpoint and the coming off the road and those things, but why isn't the motion broad enough to cover anything that may be in violation of the United States Constitution when it is broad like that, and the burden is on the state to show why evidence seized as part of a warrantless search or seizure was lawful?
And I think I'm out of time again, so if I could just briefly respond. I think that it's this.
We'll give you another minute as well, so we can need all your time there. Thank you, counsel.
Thank you, Your Honor. I think it's the state's burden to meet the arguments that are presented in the motion to suppress. So it's the state's burden to put on a prima facie case that it had reasonable suspicion to stop the vehicle. And that's exactly what the state did here by presenting evidence and testimony from officers that they possess reasonable suspicion prior to the seizure. Now, if Mr. Alvarez had some argument that something else happened, something illegal happened, some violation of the Fourth Amendment or any other constitutional provision happened after the vehicle was stopped, and had that been an issue that the trial court was considering, it would have been the state's burden to put on evidence sort of disproving that or negating those contentions. But it just wasn't an issue that was raised before the trial court. And so with that, Your Honors, I would just urge the court to reverse the trial court's order granting the defendant's motion to suppress. Thank you.
Thank you. We'll adjourn. Mr. Soar?
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
All right. Thank you both for your
Thank you.
arguments, and you're free to drop off now.
Thank you.